All right, hi again, Attorney Steve Vonder, and we are talking in this video about top defenses in software audits. Now, this video deals with getting those software audit letters from organizations like the Business Software Alliance, who represent Microsoft, Adobe's, and others, or companies like Autodesk, who audits individual companies, architects, engineers, designers, to make sure that they're in compliance with the licensing requirements. In other words, they're buying enough licenses to cover their organization with software. Okay, so these are some of the top strategies to keep in mind if you find yourself involved in one of these audits. One, lost receipts. So a lot of times you end up in these audits and the lawyers for the BSA or the lawyers for Autodesk or other publishers, there's a lot of other different publishers out there, they may ask you for receipts, and if you can't find your receipt, they may tell you you're out of compliance and you need to buy new software and destroy old software. Okay, well, that's not necessarily true. That's, of course, their point of view, but they're just a private organization. What they're telling you is not the law, and you should probably question it and say, well, look, just because I don't have receipts from something back in 2010 when I installed these different programs, Microsoft Office or Windows, doesn't mean I didn't pay for it. Lost receipts is not against the law, okay? So that's a common thing to look for. Number two, your statute of limitations. Generally, for copyright law, you're looking at 3 years. 3 years from the date the publisher knew or should have known that you were infringing. Now, a lot of times when you're initially installing software, companies like Microsoft, from what I've read in other pleadings and whatnot, they do have the ability to activate your product keys, at the time that you're signing up and registering your software, and that's a good time for them to be on notice of the time when they believe you're valid or you're infringing. So be cognizant of that. A lot of times when I deal with opposing counsel, they don't want to bring up dates. They don't want to bring up the fact that the software was from 1998 or 2000 or 2005. But those are things that should be challenged, because if you've had software that long, nobody's objecting to your use. You should be considering a statute of limitations on some or all of the products that are at issue. Okay, now that doesn't always mean it's going to save the day for you. It just means it's something to keep an eye out for. Okay. Number three, showing other kinds of evidence, product keys, the discs, the boxes, sometimes certificates of authenticity. Although many of the companies don't want anything aside from dated proof of purchases, when it gets down into the nitty gritty and you're thousands and thousands of dollars off in negotiations, you may want to be offering to show them other forms of evidence, which would hopefully prevent them from wanting to file a lawsuit, because they see that you're properly licensed and, there's some other steps they can take to try to verify your ownership of the software, and providing other forms of evidence may be helpful. Depends on your case, depends on the firm that you're dealing with. Number four, innocent infringement. Okay, so in copyright law, there's two different kinds of infringement. There's willful infringement. That's where you intended to download, steal, pirate software, or maybe you're downloading software on a torrent website. That could be deemed as willful infringement, using crack codes and things like that to circumvent access control technology. But however, there is also a concept known as innocent infringement. Innocent could be something where you didn't know, or somebody else in the organization, maybe an IT guy who left, a departing IT guy may have installed some of the software. You may have a defense where you say, look, this isn't willful, this is innocent. There's a big difference in damages under the copyright laws for innocent versus willful. Willful infringement can go from $30,000 up to $150,000 per infringed title. Innocent, on the other hand, could bring as low as $200, $750, or other amounts, depending on your judge in your case. So it's important to always be making the case for innocent infringement. Why? Because they're always making the case that it's willful infringement, and somewhere in there is the deal to be had. Okay, and finally, tip number 5, opt-out. Opt-out is maybe not a defense, but a strategy to one of these audits. These are not government mandated unless they can prove to you that it is a contractual audit, that you are contractually obligated to go through with this audit. You may just want to simply opt out of the audit and say, look, we have no need to be fearful of our licensing position. We have receipts. We've been around. We buy our software, and we are simply not going to participate. These are voluntary audits, and that's something that's very important to keep in mind when you're dealing with opposing counsel in these types of cases. So this is general legal information only and not legal advice. It's best to check with a copyright infringement lawyer. Software licensing, we can help you with that. We offer a free initial evaluation and discussion to help give you some tips that may be helpful in your case. And we offer low flat rate fees if you're looking for legal representation. Okay, this is Attorney Steve Vondran. We've helped lots and lots of companies, and we can help yours. So if you have further questions, find us at our website, attorneysteve.com, and feel free to share your comments below in the video box. Thanks for listening. If you enjoyed this video, please feel free to share it on your social media networks. Attorney Steve Vondran, licensed practice law, California and Arizona. We are out. We'll talk again. Thanks a lot.